Welcome everyone to this Privacy Rules, Privacy Espresso episode. Today I'm joined by Gabriel Avigdor, a legal expert for the Privacy Rules Alliance for the Swiss jurisdiction. So thanks, Gabriel, for being with us and welcome to this episode.
Thanks so much. Great pleasure to be here again.
Thank you. And the reason why we are here with Gabriel today is that we are getting closer to a relevant date in Switzerland. That is the Swiss Data Protection Act that will be starting in September 2023. So we're going to see with Gabriel which are the main features of this law and which are the difference with the GDPR and what should company know about it in order to get prepared. So I think that, Gabriel, we can start with a quick overview. So which are the most relevant changes from the old version and how do you foresee it?
So to start with, let's say a quick introduction, I think we need to distinguish between companies who are operating in Switzerland only and who will be subject to the new Swiss Data Protection Act and not the GDPR, because there is no processing of personal data of people located elsewhere, as opposed to companies or bodies that are also subject to the GDPR. So I would say, first of all, if you are a company or a body with experience and exposure to GDPR, you should be in a good place. That's the first thing. And then for other companies who are local, mid-sized companies with less maturity in data protection, data privacy, well, you need to take into account the fact that key principles taken from Europe are now in the law. Generally speaking, the Swiss Data Protection Act takes into account all the privacy principles that were before, like lawfulness, minimization, and proportionality, accountability, and so forth. So all the basic principles, including data subject rights, privacy by design, privacy by default, are still here. But we need to note that there are some changes. So before, for example, there was no obligation to be transparent except for sensitive personal data collected. Now there's an obligation to be transparent, which is a best practice elsewhere. So now you need to be transparent and tell exactly what data you hold, for what purpose, and how you do that in a privacy notice. So we take, let's say, kind of a GDPR approach with a Swiss finish, a Swiss touch. And this Swiss touch takes into account the flexibility, I would say, of the law, that it's a bit more flexible than the GDPR, and it aims to be more open to business, as Switzerland has always been advocating for. So if you know the GDPR, you basically know almost everything that you need to have. Maybe we can speak a bit about the differences between the Swiss Data Protection Act and the GDPR. If we take the structure of the law, first of all, as opposed to GDPR that takes into account any types of processing by any types of controllers, the law still is divided between private entities and the public sector. So you still need to have certain types of rules depending on whether there's a public body or private entity processing personal data. There is still the accountability principle, so basically no disclosure anymore as a general rule, but there are certain types of disclosure that you may have to conduct with data transfers, for example. There are also exceptions to that. You need to have records of processing. It means that you need to know what you do, what data you collect, with whom you share, how long, what is the purpose, what security measures are applied. So basically the accountability principles is all translated into a records of processing, which was before handled by the DPO. It could be still handled by the DPO. There's no clear obligation on that. There's also a DPIA obligation. It's a new thing. So if you understand what is a data protection impact assessment in Europe, almost the same type of rules apply when there is a sensitive high risk to the rights and freedoms. Let's say the personality of individual data subject. There's also incident management rules. So there's an obligation to report incidents, meaning that when there is a data breach, basically, you need to assess whether you need to report that to the authority. This is new in Switzerland. There's also a need when there is foreign company operating and offering goods and services in Switzerland, then you need to have a representative. Kind of the same rule to apply to foreign companies. There are many other slight differences and changes to some definitions. So some more have been added to the law. There's an obligation to inform about automated decision making. So when there is an AI system or any sort of automated decision making without a human participating into deciding what to do with the data, well, there's an obligation to be transparent and explain that to the individuals. In a nutshell, the main changes, and there's also a sanction mechanism that we can talk about.
Yeah, and I mean, from what I'm hearing, I would say that the key, words for this implementation are transparency and control over data. In general, also in relation to what you were saying on GDPR, which do you think that can be the main issues for companies and advantages of this revised act? I heard you mentioning sanctions, for example, and why sanction and what else?
So in terms of sanctions, the Swiss approach is completely different. First of all, the GDPR is that processing activities is not allowed unless you have a legal basis. And in Switzerland, it is important to understand that you can process personal data unless it's prohibited. Fundamental change. Now, in terms of sanction, the sanction mechanism in Europe means that there are administrative fines that can be issued by data protection authorities, which is not the case in Switzerland. You need to file a complaint as an individual, a criminal complaint to the police or to the prosecutor in order to do that. So as an advantage, I would say that the mechanism for enforcing privacy law in Switzerland is less strict than in the GDPR. But on the other hand, it's criminal. So it means that personal criminal liability for willful breach of the law, negligence is not enough, would be a disadvantage for the controller. So the controller could be fined criminally up to 250,000 maximum fine Swiss francs if it becomes that there's a criminal liability that is personal. Otherwise, if we cannot find and it's a disproportionate effort to enforce and make an investigation on the processing, then the company can be liable for a maximum of 50,000, which is nothing. So this is an advantage for companies and a disadvantage maybe for enforcing the rights.
Okay, and any other difference that you would like to underline? Also because we are running out of our time, so we have 1 minute. So
in 1 minute, I think it's important to say that data transfer use the same type of mechanism with whitelisted countries. So when you have the Federal Council issuing the whitelisted countries, probably we use the same type of assessment to understand the risk abroad. Legal basis, it's permitted unless not permitted. Remember that consent is not to be used all the time. It's only to be used when it is necessary to ask consent and there is no private interest, such as it's similar to legitimate interest, but broader. A bundled consent is still possible in Switzerland. It's important. There's no prohibition to have a multiple purposes with one consent and one tick box. This is a major difference with the GDPR. And finally, there is also one fundamental element in Privacy Act of Switzerland, which is to have a data processing agreement, what is called an outsourcing contract. Basically, as a controller, when you use a third party, having a written contract to address privacy obligations with the third party you work with are fundamental. You need to have that in Switzerland. It was the case before, but I think fundamental difference is that Article 28 of the GDPR is very prescriptive in terms of what you need to have in terms of clauses into the agreement, as opposed to Switzerland. Very minimal elements needs to be in the data processing agreement. One very Swiss-Finnish type of difference is also that you have a kind of a secrecy obligation in the law, which is very unique. Basically, the law introduces a concept of confidentiality, where when you get to know information or personal data in the course of your job, it is covered by a kind of confidentiality or secrecy. And if you breach that secrecy, you can be subject to fines. So this is very Swiss-Finnish difference that you do not see in Europe.
Definitely a peculiarity. Definitely a peculiarity of your law. So thanks a lot, Gabriel, for this. I saw many big differences, even if we are speaking about one of the few laws adequate under GDPR. So it's interesting to see that there are still some key differences to keep in mind. So good for our audience and our listeners to know about those points. And of course, we invite them to contact you for any additional support in Switzerland. So Gabriel, I would like to thank you very much for being with us today and to thank our audience, and I invite you all to join our next Privacy Espresso. So thanks again, Gabriel, and bye everyone.
Always a pleasure.